Good morning.
Good morning, Your Honor. Good morning, and may it please the Court. I think we should take as the Court's first question, the question presented in the invitation to amicus, if that's all right, because I think it gives us a chance to look at some of the critical facts of the case. What we're talking about here is the sale of participating whole life insurance. We know what that is, but let's remind ourselves. It's the way that individuals, at private expense, provide for the care and support of surviving spouses and children, concepts that have played a role in some of the Court's recent jurisprudence. When a mutual insurer sells a participating whole life policy, he is not placing a product into the stream of commerce, a jurisdictional concept that underlies a lot of the cases here. What the insurer sells and what the buyer buys into is a financial relationship. That financial relationship, by definition and by the seller's design, is a financial relationship that lasts a lifetime. Now, we have an illustration of that in 4 pages of the record. In my own view, the 4 most significant pages of the thousands in front of you. AARP was kind enough to pick up on the significance of those 4 pages and included it as the last 4 pages of their submission. What you see there is a policyholder that puts more than the cost of insurance into his policy. He builds value. He builds equity in his policy. That equity over time produces a dividend. On page 931, I believe, you'll see how that dividend is projected to cover the cost of her premiums after a fixed number of years. In this case, it was 7 to 10 years. Incidentally, these pages, 929 to 32, these were training materials for Berkshire's agents. Chief Actuary Palmer saw the significance of building equity in the policy when he was deposed. That's at pages 1129 and 1196 to 97 of the record. After time, the income produced by the value in the policy, in addition to the cost of insurance, would provide for cash outlays to the policyholder. That came up in about year 26 of these illustrations. That's what the policyholder bought into. That's what he agreed to take on. He was basically hiring the insurance company, in a sense, to manage his money for him. Now, the plan sounds great. What's the rub? The rub is the assumptions that underlied the policy illustrations. For an example, I'm going to cite you to the Moelis situation. Moelis signed on for a 10-year policy, 10-year period for out-of-pocket premium payments. After 5 years, he was told he only had 11 years to go. And then there was a change, and then it was 9 years to go. Those are pages 72 and 441 of the record.
I'm
yes,
sorry, could I ask you a question?
Please do.
The defendants say that you now claim that the plaintiffs now claim Superior Court erred by failing to consider certain facts and ruling that there is no personal jurisdiction over out-of-state policyholders, even though plaintiffs failed to bring such facts to the Superior Court's attention, even when specifically asked at oral argument. How do you respond to that?
Your Honor, I remember the passage well, and I'll say this, that what we said at oral argument was that the evidence that was presented in the briefs should be enough. And in many courts it would be, for example, in the Mooney decision and the Rakes decision. Those contexts were seen as enough. In the Arcilio decision out of the Michigan Court of Appeals, those were enough. If we're dealing with a higher standard here, I have no qualms with that, because in Massachusetts, you might hold people to a higher standard for minimum context, but we satisfy them here as well based on the existing record, and that's why we've, without trying to supplement the record, we've focused on some things in the record that may have not been emphasized in the trial court.
Could we talk about the question of whether or not the non-residents have the right to opt out of this class? Wasn't part of the judge's decision based on the fact that Massachusetts requires an opt-out provision for certification of a class, and here you can't do that for non-residents?
Your Honor, I'm delighted you asked that question, and I'm going to answer it in a twofold way that draws largely on the Baldessari decision. Yes, the Massachusetts rules do not explicitly provide for a right to opt out, nor does Section 9.2. But Massachusetts has a long, long common law tradition. And the case that I found was Fanchula versus BGS Theaters, this court's decision in 1937. The courts have wide power to do justice and to accomplish and to adopt procedures to that end. Okay? In Federal Rule 23, there is an explicit provision that when you move for class certification, you've got to move and the court has to issue an order. There's no comparable provision in Massachusetts in Rule 23. Now, does that mean that a class is certified on pleading because there's nothing in the rule that prevents a judge from issuing? No one addresses it like that. And the Baldessari court explicitly said, no, courts have the inherent power. And it goes back the courts have inherent power to adopt procedures, and if they want to require a motion, of course they can do that.
Okay, what about Phillips versus Schutz?
Phillips versus Schutz addressed, first of all, a much different situation because you don't have the context that the policyholders here have here, and that's why I wanted to lead with the facts. Phillips versus Schutz does say for non-residents who have no minimum contacts, you have to give them an opportunity to opt out. But that's not, first of all, that's not the decision that we had, the case we have here, because these policyholders, based on the pages that I've cited in the record, they buy into a relationship that gives them far greater contacts than the contacts of the defendants in Good Hope and Tattrell.
Well, what they've done is purchase insurance, the non-residents.
They purchased insurance and they
That's
bought
your
into
contact with Massachusetts.
No, I think it's more than that. That might be the situation in Markham, Your Honor, where there's no indication in the record of any long-term consequences. But here, clearly, the policyholders were buying into more than just this was not buying insurance on an installment plan. This was building a financial relationship where you depended on your insurer to invest your money, to give you a return, and that return would pay your premium, and that return would provide you with income at a later date. Those contacts were far greater, and that's what the Michigan Court of Appeals decided in Arcilio, a very well-reasoned decision that said when you buy into a mutual company, you're availing yourselves of the protections provided by Michigan law. And that's what we've got here. We've got policyholders who avail themselves of the opportunity or of the protections provided by Massachusetts law.
Well, if I buy the product from an agency in California, presumably I'm availing myself of the protections of California consumer protection law, right? I mean, that's what I'm availing myself. I don't think about it. I'm availing myself of where's this company from again? I mean, and I'm in California, and I get notice that my rights are being litigated in Massachusetts. I say, I don't think so.
Well,
I've got rights under California law, and I purchased my policy here. What do you mean they're going to be litigated?
Twofold answer to that, Your Honor. One is that as the United States Supreme Court recognized in Allstate and in Schutz, there are certainly going to be disputes where more than one state's law could apply. And we have not taken the position here that a policyholder could not bring some sort of dispute against his agent or indeed against Berkshire in California. But the law of Massachusetts provides that dispute can also be brought here. Well, I guess another example is Bushkin, Your Honor. Bushkin,
I don't want my rights litigated in Massachusetts. Period. I bought this in California. I have a lot at stake here. I don't want to have to hire a lawyer to go out to Massachusetts. I don't want to depend on these folks that I never heard of. I want out of this case. Can't get out.
If this case rises or falls, Your Honor, on the opt-out right, then I think this court should give serious consideration to the source of the opt-out right and how it applies to Section 9.2. You could change the Fletcher decision and provide for an opt-out right without changing the language of the rule and without changing the language of the statute. The only thing that Fletcher had to say that there was a no opt-out right was an offhand comment by the reporter saying this rule does not expressly provide for an opt-out right.
So that's what you're suggesting we do, because it does.
Well, I'm not suggesting that this court has to overrule Fletcher to reach a just decision. But if you don't overrule Fletcher and you decide there are no minimum contacts, then you're essentially throwing Tattrell and Good Hope into a jurisprudential mess because the contacts here were far greater than the defendants had in Tattrell and Good Hope. And if you take that position, you're not talking about constitutional adjudication in a neutral, principled way. These plaintiffs have more contacts and they're subject to jurisdiction. Furthermore,
I can't understand why we have more contact. I mean, why they would have more contacts. I assume they send their premiums to the company. They don't get financial advice from the company. They're not, it's not my stockbroker. I'm not calling them saying, okay, let's invest the proceeds this way or that way.
Oh,
I send my checks there.
I disagree, Your Honor. Then that's why I go into the illustrations. And look at the 15 pages that follow in the record, that follow those illustrations I've cited. That's about page 932 to 955, where you have what the policyholders were sold. Pay 10 years, pay 10 years in and lifetime payout. Other places, pay one and all done.
Yeah, but
These policyholders were buying into a serious financial relationship, relying on Berkshire to invest their money and provide a return. But I'll add one more point to that, Your Honor, because what you've got here is Berkshire, very kindly, basing its brief on asserting just tertiary the rights of policyholders. Berkshire doesn't make its own minimum contacts argument about its own minimum contacts interests. All Berkshire does is assert just tertiary the rights of the policyholders. Well, if we think there are policyholders who really aren't going to like this, why are we afraid to get their views on it? Why are we afraid to send out a notice to them saying, we're trying to get some economic recovery for you on that phantom insurance that Berkshire sold you back in 1990, and let's see how many of them write back and say, oh, economic recovery is all right, but I'd really prefer my constitutional rights, whatever they might be.
So we do this before we certify the class? We send out a notice that anybody have a
Class
problem with
certification
this?
decisions, Your Honor, are not etched in stone. They can be changed. If a court gets overwhelming opposition to this class certification, it can change it. No, I think class gets certified and you send out mandatory notice under 9-2.
You know,
Another
I
concept that
hate getting these notices in the mail, frankly, but it seems like everything I ever bought in my life is subject to a class action everywhere. I don't even read them. I mean, it's not my state. It's Idaho. It's some other place. They're litigating some shaving machine or something that I must have bought when I was 16.
Think of plaintiff Helen Koyman, Your Honor, with all due respect. You know, it's hard paying these premiums on a fixed income, but we have to keep the insurance going. That's what this case is about. Or this case is about guys like Herbert Moelis who pay $40,000 a year for 5 years, and then they find that their projected period for out-of-pocket payments is not the 10 years that they were sold, but 14 or 16 years. And make no mistake about it, this case is about thousands of people out there who died or will die without the insurance they bought and without providing the care and support for surviving spouses and children because Berkshire sold them something that it couldn't deliver. That's how serious this case is. Now, you can say abstractly, we want to protect their constitutional rights. Well, let's give them a chance. Let's certify this class and send out a notice and see how many of them are more concerned about whatever these constitutional rights are as opposed to trying to get something back on this bill of goods that they were sold by Berkshire.
No one's suggesting that their claims should be cut off. The question is how they get litigated, in what form, whether they get litigated here for everybody around the country, not whether they have claims.
Your Honor.
Maybe a lot more convenient for someone in California to litigate with local counsel their claims right there if it's so important to them.
Those are excellent questions, and I'm delighted to address them. Remember that we've been here for 10 years now. Okay? Are we going to have the suggestion of the briefs was that I was engaging in sophistry for hiding the fact that we could have 40 separate state class actions. Do you know what that means in this case? 40 more improper removals, 40 more improper 40 more motions to dismiss that are completely abandoned when the case is remanded to the less favorable form. 40 more two-year discovery disputes just to get the basic documents. And 40 more summary judgment motions. And what are they looking at? You've got 40 courts looking at the same deceptive conduct, all of which took place here in the Commonwealth.
I have a question on a separate issue. Would the
Please, Your
dates be different as to each plaintiff, as to when each plaintiff received the insurance policies, the annual statements, of the actual bill and the actual bills for the premiums beyond the disappearing year, et cetera? I mean, are these all, would these different dates all mean that there were different dates for the statute of limitations purposes?
Another excellent question, Your Honor, and I'll do that as well as I can with the yellow light on. The focus of the statute of limitations inquiry here, Your Honor, is going to be on what Berkshire knew and what it told the policyholders and what it did not say. We've been through this. You know, this is not some statute of limitations, is not some sort of brooding omnipresence in the sky, the mere specter of which forces you to run for dismissal. You've got hard facts here, including all the things that Justice Botsford looked for in the court below, saying these do not, as a matter of law, put the policyholders on notice that they've been deceived. Okay? Now, anything else is going to arise out of Berkshire's files. No policyholder, no matter how sophisticated he is, can evaluate information that the policyholder doesn't have.
No, but
And
I'm
what
just-
you've got,
I'm-
what,
But
sorry,
I'm
Your
just
Honor.
saying that the date the person bought the policy is always going to be different, and the date that each plaintiff got something. Doesn't that make for all different statute of limitations dates? I'm looking
Certainly,
at it from that
the
view.
fact that, yes, the fact that the policies were delivered at different times, Your Honor, makes a difference. Our plaintiffs here had policies that were delivered over a 10-year period. But the court below found that there was no running of the statute of limitations for any of them. Why is that? Because Berkshire was the party that knew how interest rates would affect its portfolio income. Berkshire was the one that understood how its portfolio income would affect its dividend scale. And Berkshire was the one that understood how changes in the dividend scale would affect the out-of-pocket payment period. And Howell Palmer and Chief Executive Cornelio both testified to that. Cornelio, I wish I had a DVD of Cornelio looking at me when I said, well, could a policyholder tell from changes in the rates of interest how his out-of-pocket premium payment would be, how his period for out-of-pocket premium payments would be affected? He looked at me like I was nuts. I didn't tell him that it was his lawyer's argument, not mine. But that's the critical statute of limitations inquiry. The things you're addressing, Your Honor, all have to be considered. But they can be done administratively by looking at dates, periods. There might be some differences in disclosure forms. There might be, what's more likely to, what might come up is information in Berkshire's files saying, we told you in 1999, or we told you in 1992, to get an alternate illustration or something of that sort. If that's in Berkshire's files, it's going to play a role. But the pattern is that it's not. It was not in the files for these plaintiffs.
Do we know how many policyholders we're talking about?
Well, what we know to date, Your Honor, is that Berkshire's told us there are about 4,000, but there's some qualifications in that to be dealing with access to a computer system that was allowed to abandon.
And what about the statewide distribution? All 50 states?
We have about 10 states, Your Honor, where you have 100 or more policyholders. In fact, I'm not even sure it's that many. Out of the 42 states where we have policyholders, Your Honor, 25 or 30 of them had under 50 policyholders. So it'd be highly unlikely you could even manage a statewide class with under 50 policyholders. And it's highly unlikely, I think in response to Justice Gordy's comment earlier, it's highly unlikely that you could get economic relief. Because it's a practical matter. Who can go through this kind of dispute? And I've described the years of litigation. It's a practical matter. Who can afford to do that for what might be a $10,000 or $20,000 recovery? This is not, by the way, Justice Cordy, one of those cases where you get $3 or $4 back and the lawyers
No,
make
there's a
ton
lot
of
at
money.
stake in this case, which means there's
There-
a lot of reason why these cases might get litigated, even if it's not a national class action.
Well, but as a practical matter, Your Honor, certainly in Massachusetts and New York, you don't litigate a dispute for $10,000. With a 2-year discovery dispute and all the briefing that's going on, you don't even cover the expenses for that kind of money.
I thought there was a lot more money at stake than that.
Thank you, Mr. Shager.
Thank you, Your Honor. I should say, if the court will permit me, if I've caused offense, it's my fault, but if I said anything that appeals to you, it's probably the credit of my colleague, Mr. Douglas Brooks of the Boston Bar. Thank you.
Mr.
Good
White.
morning, Your Honors. May it please the Court, I'm Brandon White for Berkshire Life Insurance Company. The Superior Court properly denied class certification, both on a nationwide and statewide basis. The nationwide class requested by the plaintiffs would be unconstitutional, as it would deprive the out-of-state class members of their due process rights.
You're really representing the out-of-state class members and representing their due process rights? How can you fairly do that?
I am not doing that, Your Honor, but in addition to the deprivation of due process rights of out-of-state class members, you also run into a problem from Berkshire's point of view, which is that if you did have a national class action conducted here, it would not be res judicata or collateral estoppel vis-a-vis all those people from around the country who are not properly subject to this court's jurisdiction. It would be collateral estoppel, presumably, vis-a-vis Berkshire, and then Berkshire could be sued again and be defenseless around the country. So that's one of the reasons why it's important to Berkshire that we not certify a national class without in personam jurisdiction over the class members. Additionally, there's another reason why we cannot certify a national class here. the Massachusetts long-arm statute will not reach those out-of-state class members. I'll explain that in a moment. That's a separate point. And here's what I have to say on the statewide class. It fails the similarity requirement of Chapter 93A because, as I will show, the statute of limitations defense necessitates individual inquiries under the discovery rule, as Justice Cowan was mentioning, as to when each of the thousands of members of that class were put on notice that their policy wasn't performing as expected due to some alleged wrongful act by Berkshire. Now, as we have already heard, the plaintiffs are trying to certify a nationwide class that consists of 4,000 people.
Why isn't that last point, though, really subject to the administration of the case, as opposed to, I mean, why can't that be managed administratively in the claims process after underlying liability has been determined one way or the other?
Because, as Justice Botsford noticed, it is literally unmanageable. You have to look at the Massachusetts law about the discovery rule under the statute of limitations. The clock is going to start ticking on any individual whenever that person knew or should have known that they had a claim to make. In order to understand whether any person knew or should have known that they had a claim to make, you are going to have to understand the respective financial sophistication of those individuals. You can't examine someone's actual knowledge of a claim without examining that person.
Doesn't this come up all the time in class actions? Isn't this managed all the time? Just because there's a statute of limitations problem in a class action doesn't mean it can't be litigated.
It is sometimes managed and it sometimes isn't. Let me emphasize that it's a matter of the trial judge's discretion.
Mr. White, can I just ask you that on that question? In this context, assuming, it's the knew or should have known, what's the should have known piece of that? Is it an article in the Financial Times? In other words, as I understand it, how would Berkshire claim to meet the should have known standard?
Okay. The should have known has to do especially with what we can refer to as post-sale communications from Berkshire through its agents to the policyholders, and the point about this is how various they were. Berkshire spent a lot of time and effort both in writing and orally saying things to its agents so that the agents could pass them along to the policyholders. But when you're talking about 4,000 policyholders and hundreds of agents in 39 offices around the country who are speaking to their policyholders orally or passing along documents to them, things are going to reach different policyholders at different times and are going to have different content. We can give you some examples.
Why should that burden fall on the individual policyholders rather than Berkshire? Berkshire could have said, I'm only going to communicate. You can only communicate in writing, and here's the writing, and this is the day you send it out. I mean, Berkshire was the one that chose to rely on oral communications.
And when you're analyzing the should have known question, or even actually the did know question, you have to look at what in fact came to the persons who want to be the plaintiffs and when it came to them. You also have to look at what else they knew when the information came to them. So you have to start looking at these people at the first moment of the point of sale. They're complaining about some kind of illustrations that were shown to them. But those weren't the only thing communicated to them at the point of sale. There were oral communications from the agents to 4,000 different people at the point of sale. Now you have a context to begin examining whether a person who heard one of those 4,000 communications...
Why should Berkshire get the benefit? They've got written communication, and the agent says, oh, don't pay any attention to that.
This is the way the statute of limitations and the discovery rule works. As the cases have said, once Berkshire demonstrates that it's been more than 4 years since the alleged wrongful act before the time of suit, the burden shifts to the person who wants to evade the statute of limitations to make the necessary demonstration that the clock didn't start ticking. And the burden is on the plaintiff.
No, I understand that.
I didn't know, and I couldn't reasonably have known. The problem with...
Why should Berkshire be permitted to rely on anything other than its written communications to its shareholders, to its policyholders?
All we're talking about is the right that any defendant has in a statute of limitations discovery rule case. Any defendant is able to call upon the plaintiff to prove that the plaintiff didn't know, and could not reasonably have known of its cause of action.
But you're telling me to rely on oral communications. It seems to me if you're relying on written communications, then it's perfectly easy to administer them because you just look to see where Berkshire's written communications are. Now, if you throw in, I don't know what our agents said, I mean, you're essentially saying that it's, there's no possibility of any similarity ever. Whether or not the agent was authorized to say it, whether or not the agent individually engaged in some kind of false representation, why does that cut off an individual policyholder's rights under our law?
The reason it's so important in this case is because of the nature of the case. It starts with the fact that the plaintiffs are trying to certify a class that goes all the way back to January 1st, 1980. But the first time any of them sued Berkshire was August 19th, 1998. So there you have an 18-year problem for the plaintiffs to have to overcome. That's extraordinary. It's not just a little bit outside the statute of limitations.
So let's say if Berkshire, for example, sold a policy in 1983 and in 1984 sent out a notice to all of its policyholders that, the hypotheticals that we gave to you are inaccurate. It seems to me that somebody could look at that and say, well, we can manage that.
And the issue is much more complex than that because there isn't a black and white statement that people are complaining about. It isn't that Berkshire said up and the fact is down and Berkshire later said, oh, it's really up. This is, as counsel pointed out, a complicated communication between somebody who is selling a financial product and somebody who is buying a financial product. The plaintiff is complaining that an illustration that was shown to the plaintiff by an agent for Berkshire somehow didn't disclose everything that it should. Berkshire is taking the position, and it's logical and common sense. These agents were out there not just silently handing over the illustration, they were out there making the explanation to the policyholder orally at the time. Beyond that, that's only the context for examining when a person knew or should know that he or she had a claim. Beyond that, you do have both the written and oral communications that Berkshire sent out over 13 years to these policyholders through these agents. This is not one moment when Berkshire said, there's something wrong, here's the difference, and everyone would know that they should sue. These are a variety of communications. Some of them are in the record. Sometimes Berkshire would recommend to its agents that they illustrate for the policyholders the way changes in interest rates were causing changes in dividend rates and were thereby causing changes in how long the premiums would have to be paid. It's not a simple matter and not something that happened all at once. In 1993 and 1994, there were more notices from Berkshire about the possibility that some people's premiums could reappear. That's another group of people that had something to pay attention to, and it's their burden to show that when they saw that, it's not that they should have known they had a claim. We have also in the record letters from policyholders to Berkshire in the early 1990s saying things like, I thought my premiums were going to disappear in 7 years. Now it's the 8th year and I'm still getting premium notices. That's an example of a person who arguably knew or should have known years before bringing the claim that there was a claim to bring. This is why Justice Botsford, in her discretion, decided these matters were not manageable by trial management techniques. It's thousands of people, it's 13 years, and it's almost everybody who's outside the 4 years and who carries that burden of showing that they didn't know and shouldn't have known.
Well, she denied without prejudice, didn't she, on the statute of limitations issue?
She did. I think she properly put the burden on the plaintiffs to come in and show that it isn't true, that there are a lot of different communications to a lot of different people, and that somehow it all could be a matter of a finite number of communications to a finite number of people at issue. Yes, she denied it without prejudice with that reasoning. One of the things I'd like to do while I have time is go back to the constitutional question because I think it's very important. It has to be understood that in this jurisdiction, we do not have an opt-out. Under Rule 23, you can't opt out. Under 93A, you can't opt out. It also has to be understood it's not just Fletcher versus Cape Cod Gas that you would have to overrule to give us an opt-out under 23 and 93A. You'd also have to overrule Weld v. Glaxo Wellcome Inc. from 2001, and I believe there are other SJC cases that recognize that we don't have an opt-out. So you'd be overruling at least 2 cases and rewriting the 2 statutes. I suggest that there's no reason to be doing that.
Why would we have to rewrite the 2 statutes?
Well, they don't have the
No, I
federal
understand,
provision of an
but
opt-out.
It's our judicial gloss on them, right? I mean, you can do it by statute, but we can...
Yes, my argument is that there's good reason why this court has said there's no opt-out, which is the different way our rules and statutes are drafted compared to the federal rule that does have the opt-out. We are not the only state that doesn't have an opt-out. I've noticed in my reading, for example, that Maryland doesn't have an opt-out, and there may be others. And once you understand that we're operating here with no opt-out, the next thing you have to understand is that the court cannot certify a nationwide class unless it can exercise personal jurisdiction over all of the out-of-state class members. Also, this Massachusetts court, the Superior Court, cannot exercise personal jurisdiction over non-resident class members unless those non-resident class members have the same level of minimum contacts with Massachusetts traditionally required to support in personam jurisdiction over out-of-state defendants. This is the law of the United States Supreme Court from Phillips Petroleum Company versus Schutz in 1985. And this is where the Supreme Court said that to protect the due process rights of the out-of-state class action plaintiffs, either the state must provide an opt-out or the trial court must find the same level of minimum contacts you need in order to sue someone here and make them be a defendant.
I don't think the court was quite that specific, was it, on that last piece?
I believe that the court on pages 811 to 812 of the opinion, it should properly be read, as Judge Botsford read it, to be saying just that. The court does speak in terms of the contacts of defendants, and then goes on and speaks in terms of not having those, then you need an opt-out. The entire opinion, I believe, is oriented in that way, but I would look at 811 and 812 for the best language. Now, there's no double standard, of course. It is the same contacts you need, because the person who is being brought in as a class action plaintiff with no opportunity to opt out is facing a final determination of substantive legal rights and rights to money damages by compulsory process under those circumstances, making that person just like a defendant. The Superior Court made a correct determination in this case that these out-of-state policyholders don't have the required level of minimum contacts with Massachusetts.
How do you respond to the Michigan case?
The Michigan case is distinguishable from this case because there was actually another important contact mentioned in the Michigan case. That was a case, I could show you this because it's really a very good quote in the Michigan case that makes the matter clear. I'm looking at page 12 of the opinion here, but it says, on page 13, it says, but for their status as policyholders of an alien insurer domiciled in Michigan, respondents would have no standing to maintain their federal action. Accordingly, respondents' minimum contacts with Michigan provided reason to expect to be hailed before Michigan courts. Here's what these people were doing. Outside of Michigan, they were bringing a lawsuit, a federal suit, against the carrier that the Michigan Division of Insurance was trying to rehabilitate within Michigan. And the Michigan Division of Insurance decided they're acting outside Michigan by bringing a lawsuit, causing a disruption inside Michigan to the Michigan insurance company that the Division of Insurance is trying to rehabilitate. And the court said bringing that suit out there outside of Michigan is enough contact to lead these people who are bringing that suit and causing that disruption to reasonably believe they're going to get hailed into court in Michigan for doing it. That is a completely different situation. We have no facts that in any way resemble those facts in our case. Now, there's another important reason beyond the lack of constitutional...
I think your time is up, Mr. White.
Okay, and my last point is the long-arm statute doesn't reach these people either. Markham, New Hampshire Insurance Guarantee Association, express ruling of this court.
Thank you, Mr. White.